Good afternoon, good evening, or whatever time zone you're in. We're just going to wait for everybody to just join us. So we'll just have a few people coming in, and then we'll get started with our session today. So I can just see that there's quite a few attendees sort of coming in. So I'll just give a couple more seconds for that to move through and get everybody in and ready for us, and then we will get started. So apologies for the slight delay. We were just getting some issues sorted out. And certainly from my point of view, everybody sounded as though they were the little mice on Bagpuss, for those of you of a certain age that can remember that. But certainly everybody sounds in the right mode now. So welcome to today's meeting. I'm Joanne Price. I have the pleasure of being the North Eastern Cumbria Chair and also the honour of being one of WRSM's ambassadors. Today we're hosting a joint presentation with our friends from WRSM's Yorkshire and Humber branch, and I have pleasure in welcoming everybody from there for those that are members and non-members. Today we'll be providing a legal update, and very kindly Matthew Brakel of DAC Beechcroft has joined us, and I'm really looking forward to everything that Matt's going to provide for us. Matt specialises in providing advice and assistance to organisations and individuals where they've been in a workplace accident, or whether it's police, health and safety, or environment, or other regulators that are undertaking investigation or prosecuting. He provides advice and representation at inquests and delivers an extensive range of training sessions from the boardroom to those boots on the ground. He does regularly provide initial advice and support in the immediate aftermath of a major adverse incident, including incident investigation, legal representation, interviews under caution, and advocacy work and magistrates course. So I'm sure you'll follow with me in knowing that that's experienced in this area of what we're going to be covering. There will be time at the end of the presentation to ask questions, so please do put them in the Q&A box rather than the chat section, just so that we can actually pull those questions out. So you've not come to hear from me, definitely come to hear more about a legal update, so I'll hand over to Matt.
Thanks, Joanne, really appreciate it, and good afternoon from where I am anyway to you all, and thank you for the invitation to address you all today. So Joanne very kindly did a nice introduction. But just to confirm, my name is Matthew Brakel, partner at DAC Beechcroft. Our regulatory team is probably one of the largest in the UK. We've got about 34, 35 lawyers, all the way from Northern Ireland, Scotland, all the way down to the south of England. And we are regularly instructed by large organisations and any organisations and individuals where they are having maybe a major incident or a fatality in the workplace. But we also are doing a lot more advisory work now and thinking about how we can use our experience from supporting clients through adverse incidents and major incidents in terms of strategic planning, strategic reviews, and some preventative training work as well. So I've been asked to do a bit of a session for you today in terms of a legal update. I thought it would be helpful, first of all, just to do a little bit of horizon scanning and looking at some changes within HSE and see how the HSE have been operating over the last 12 months or so. Thinking about some changes in terms of developments in the law. And then I think it's always helpful to have a look at what the courts are doing and seeing if there's any lessons that can be learned from the courts and from some of the cases that are coming out from the HSE Media Centre. So we've recently had the HSE's 2025 AGM and there's some key takeaways in there that are always worth having a think about. Clearly, we're well into this, but I think one of the things that for me is quite interesting and that we are certainly seeing in terms of the issues facing organisations that perhaps we've not had to deal with massively before in terms of reporting back to HSE or local authorities in particular, is around the health. We've always talked about health and safety, and the safety has always generally been the lead focus, thinking about accidents and managing the workplace so it's safe. But there does seem to be an increasing focus on health. And it's not so much the obvious health bits now. Obviously, there's going to be issues around dust and asbestos and manual handling, and we're well versed in all of that. And indeed, HSE are doing some targeting in that area. And of course, we're seeing that increased scrutiny of MSDs. But I think the thing that I'm seeing a lot more of, and I'll touch on it later, is the regulators and the general sector in terms of health and safety really beginning to focus in on the health side of mental health and well-being. And I think certainly pre-COVID, we were talking about it in sort of very aspirational terms. And then COVID came, and during the pandemic, a lot of organisations adjusted and adapted and started putting in place proper mental health risk assessments along with HR teams. And then after the pandemic, we've had this sort of practical period where organisations have had to balance and adjust, try to encourage, in some cases, people to come back to the office if they feel it's a better environment, a better working environment. But that in itself has posed problems, with some people not wanting to come in all the time, some people not wanting to come in at all, some people wanting to be there all the time, but the company maybe downsizing in terms of their workspace. And I think it's a very interesting area at the moment. I think we will see a increased focus in on less aspirational measures and more practical measures going forward. And I'll share with you a bit later a recent inquiry I've been dealing with for a client in relation to mental health in the workplace. Review of RIDDOR, expecting clearer definitions to take place, trying to make things a little bit more streamlined. And of course, we're looking at the work-related violence and road traffic not being part of that review, but HSE confirming that separate consultation on violence at work is coming. From my perspective, I think RIDDOR, and I'm sure you all face this on a regular basis, is one of those areas where, unless it's a specified injury, a lot of the time there's a lot of thought that has to go into, first of all, is something reportable? Does it fall within the regulations? Is it captured? Do I need to report it? That then second part of, well, if it does, when do I need to report it? And then thirdly, how do I report it? Not in the sense of going online and filling in the form, but how much information do I need to provide? And our view is very much that the RIDDOR system is there to notify a regulator that there is an incident that they may need to investigate going forward. It's not meant to be an investigation report copied and pasted into a form. It's not meant to be war and peace. You know, it is there simply as a notification process. And I think sometimes there's also always a bit of uncertainty. I see some RIDDORs where there's a lot of detailed information that's gone in. And, you know, I think accident investigation is important and really important. And I think sometimes just taking a step back and thinking, are we actually ready to commit to the level of detail that we're putting in a RIDDOR is quite an important question to ask yourself, particularly when you're thinking about the amount of detail to put in. And I do think we'll see further guidance coming out from HSE. I do think we'll see more information becoming available. But also, I don't think you're ever going to get past that moment of just having to take a step back and think, you know, do I need to report it, and how am I going to report it in terms of that wording? And I think that is always going to be an issue that people face, and we certainly offer a RIDDOR wording check for clients where they can just run past proposed wording before they put it in the RIDDORs, just to make sure that they feel comfortable with what they're putting in, but also there's a little bit of potential healthy challenge at an early point, so that people can think about, well, hang on a moment, do we actually really want to be saying that at this point? Are we confident in what we're saying at this particular stage? Fee for intervention, I think, is probably one of the most controversial things that has been introduced in recent times in terms of that relationship management with the HSE. I fully appreciate that the HSE may feel that they are entitled to get their costs back for dealing with any material breaches of health and safety law. But like with all things in this area, when you're dealing with the regulator, particularly with the HSE, it's very much the, in the opinion of the inspector, is it a material breach in the opinion of this particular inspector, not the HSE as an organisation. And I think a lot of the time we are not necessarily seeing consistency in the approach. Sometimes some inspectors are taking immediate enforcement action. Some are more open to a discussion. Some prefer to deal with potential issues through the FFI scheme and through notification of contravention rather than an enforcement notice, such as an improvement notice or prohibition notice. And the other thing that we are seeing a lot of when we're trying to challenge or query fee for intervention invoices is descriptions on the invoice being very generic, and it is very difficult, based on the information that the inspectors are recording in terms of how much time they've spent doing something, to effectively query some of those entries, because you can challenge a fee for intervention invoice for two grounds: one, that there's been no material breach to begin with, and two, that the costs are outside of the guidance that they're allowed to charge for. And that first one is very much down to a discussion as to whether you accept the breach or not. But the second one, in terms of the actual charging itself, that's where we have these issues with the invoices. And I do think we've got to a point where we're having to almost add up all the time it's taken on the face of it to do one particular task and say, this feels like a huge amount of time to do this one task. And then we get an email back or a letter saying, well, actually it involved this, this and this. And then when they start breaking it down further, if they can, or if they're able to, it becomes, on the face of it, slightly more reasonable. But I do think that there needs to be certainly a revised approach at HSE as to how they are dealing with it, fee for intervention. It'll be interesting to see what developments come out in this area. And of course, one thing we haven't seen that we thought we were going to see is the rollout of a similar sort of scheme across local authorities. But at the moment, local authorities don't seem to have taken that up. I remember when fee for intervention first came in, and we all said, I don't think it'd be long till local authorities start thinking about this. But at the moment, they certainly don't seem to have any intention of doing that, which I think is obviously probably quite a positive thing, because it certainly allows you to build a relationship with an inspector without necessarily being worried that you're going to get a gigantic bill at the end of it and a document says that you've broken the law. I think the one thing that I'm seeing and my colleagues are seeing, and is probably mirrored by the HSE's performance review, if you want to call it that, is the number of enforcement notices that have been issued. There's been a lot, and I do think that there have been certainly times where we've had to push back on a number of improvement notices in particular, where maybe the HSE haven't asked for all the right information, or maybe there's been a bit of confusion as to about what they were asking for when they were on site and what they were provided with, which has resulted in the improvement notice being served. And clearly the case law is quite favourable to those people that have had an improvement notice issued against them in terms of potentially challenging it, where there's been maybe that breakdown of communication. And so it will be interesting to see how those figures continue to develop in due course. Although more than 200 prosecutions were brought, with obviously a very high conviction rate, always anticipated in an area of law where there's a reverse burden, i.e. as soon as the HSE can prove to the criminal standard that a risk existed, it then falls on the defendant to prove they did on the balance of probabilities or that was reasonably practicable to mitigate or eliminate that risk. I do think it feels to us like the prosecutions are going down, although the HSE now have their own internal legal services division that I think are probably more embedded than they previously were, and probably are more settled than they previously were. It does feel like there's not as many prosecutions as there used to be. Interesting to see that 86% of fatal investigations were completed within 12 months. My experience is that the police and HSE are not always working particularly well together. And I don't mean that as a criticism, but I think following a fatal accident, we've got a number at the moment where the police are retaining primacy under the work-related deaths protocol, but it feels like they're not quite sure what they're meant to be doing. They're being heavily led by the HSE, and the HSE are then frustrated that they're not effectively the ones leading, if that makes sense, that the police are. And I do think that depending on the police that are dealing with it and the HSE inspectors dealing with it, a lot of it is down to how well they are working together as to how prompt an investigation is going. I'm dealing with several corporate manslaughter and gross negligence manslaughter cases at the moment, which are being led by the police. And there's one that just feels like it's drifting somewhere between the police and the HSE, whereas there's others where it feels like it's just been supercharged and it's just hurtling ahead. So I think it is very much down to the experience of both the officer and the HSE inspectors and how well they are working together as to how quickly an investigation is being completed. And of course, I notice that investigations complete within 12 months, but not necessarily the case itself. So I wonder how long it takes for a decision to be made at that point. And HSE will continue to embed and refine its risk-based decision-making model. And this is effectively where we have seen this new triage process. And this is a really interesting development and something that, on the face of it, I think HSE have got probably right. But on the flip side, it is creating another layer of uncertainty as to whether something's being investigated or not being investigated. So what we're seeing now is where you submit a riddle and it falls within the jurisdiction of the HSE, you will generally get an email pretty shortly after, mostly a couple of days, sometimes maybe a week or so, depending on the level of seriousness and how it's rated internally. You'll get an email from a triage officer asking for a standard list of documents, so often risk assessments that are relevant to whatever was reported in the riddle, training records, copy of the investigation report, and then they tend to then personalize the email at the end depending on the incident for some specific information. And they often put in it that they'll give you 48 hours to reply, which is clearly not great. And to be fair, we've often pushed back, I think on nearly every single time, pushed back and said, look, 48 hours is just not simply enough. And the triage team have been pretty sensible about that. And we've often said, look, we just need a week or so to get this information together and then ping it on to you. And so far, we've had no pushback from the HSE triage team. But once that information gets sent and you deal with that initial inquiry, we've got cases at the moment that were quite serious and that I thought would result in a full investigation, where we've heard absolutely nothing at all. It felt like it gone into a bit of a black hole. And then we've got other ones where HSE inspectors who are actively involved with either that client on other matters or in that area have picked it up and sort of run with it and got the information from the triage team and undertaking a full investigation. So at the moment, it's not very clear to me if the HSE triage team decide that they don't want to do anything or that it's not going to be escalated to a full investigation, we don't seem to be, as a matter of course, being notified of this. You simply send the information off and then hear nothing, and it's quite disconcerting. But ultimately, it's no different to when you'd submit a RIDDOR and sometimes an HSE inspector would be in contact and sometimes they wouldn't. So there's this extra layer where they seem to be trying to filter the cases that need to be investigated at an early stage, which I think is a good concept. But I do find it a bit frustrating sometimes that we don't find out whether or not they're actually going to do anything, and we just end up with this load of information being sent over and no clear picture as to what happens next. So again, I feel that it's perhaps something that the HSE will, in due course, try and streamline a bit better. I don't know. Maybe I live in hope, perhaps. In terms of the law, bit of an update here. Obviously, Martin's Law, as it's fondly known, is now going through the implementation period. Interesting, because there was obviously a debate throughout the course of it when people were thinking about who would potentially enforce, and it's going to be the SIA, not the HSE. So that potentially adds another layer of dealing with a different regulator, and regulators all operate in slightly different ways with different practices and codes. So it'll be interesting to see how that pads out in real life, if that makes sense. It'll be interesting to see if SIA get more involved with any guidance from HSE or any other regulators about how they operate with these sorts of responsibilities. We saw that a little bit when the Care Quality Commission in 2015, the Memorandum of Understanding between HSE and the CQC resulted in quite a number of people from HSE moving over to CQC. Obviously, the building safety regulator is based in HSE, so it's got HSE people as well. So I think we are seeing that experience sort of cross-pollinate, but it does tend to leave the HSE a little bit short on experienced people. And certainly we are seeing HSE at the moment with a huge workload. And I think that is also resulting in some delays. Now, I wanted just to spend a couple of moments on this because I thought this was an interesting development that I've been dealing with recently. And it comes back to what I was saying earlier about the health and safety. Mental health in the workplace has obviously been a big deal, and we've talked about it on a number of occasions over many years. But just recently, I've been dealing with an issue where a local authority received a complaint from a member of staff that they felt that they were not being supported very well in terms of their mental health in relation to a potential HR issue. And it was quite interesting because we then had a series of emails from the local authority asking for things like risk assessments and policies and procedures in terms of mental health support at this particular organisation. And so we provided the risk assessments, we provided the policies, we provided the procedures, and then they came back and started asking us about, well, how is it all briefed out? Where is this information available? How can people find out who they need to go to? How can they access these services? Is it easy to access? And so we then had to obviously expand upon our initial response. But I have to say, it was quite an interesting concept because although this client is very well organised and had everything in place, I do wonder how many organisations are prepared to deal with that sort of level of inquiry from a local authority that is potentially investigating under the Health and Safety at Work Act as to whether or not an organisation, particularly large organisations with maybe a large workforce, but even that SME field, asking about, well, how do you organise your health and safety matters in terms of mental health, work-related stress, people who are signed off work, what sort of level of support can they access, what level of support is there for people who may be going through the HR process or a grievance process. and how easy can they get all of that? And it did feel to me like we're taking a step in that mental health sector, one that's very familiar when we're dealing with a safety incident. So when you deal with a safety incident, as we've just talked about on the HSE triage, email, it's all about risk assessments, policies, training records, accident investigation. I don't think we're a million miles off, and I think we're beginning to see the same thing being required as would be for a safety investigation, for health investigation, for mental health in the workplace. And I think it's an interesting development. This may well be a one-off, but my gut's saying it's probably not. It's probably something that we're going to see a lot more of. And it's a real challenge because, you know, we are dealing with, certainly my team, a number of very harrowing incidents where people have been involved. There are potentially family members involved or colleagues in that particular business. And one of the things that is always a challenge once you've had a major incident, particularly a fatality, is making sure you get the right help and support in place as soon as possible for those people that observed it, viewed it, or somehow been involved in it, or impacted or affected by it. And often that results in things like being directed to the employee assistance program, or having time to go and see a GP or something like that. But I think that if this instance is anything to go by, I think the bar is certainly being upped. And I think having an employee assistance program or equivalent, and some sort of time off to see a GP, I think that will be, in essence, the basic that should be offered. And I think, like a lot of things in this area, it will come down to how well policies are drafted and how well that information is briefed out as to how well you can demonstrate that you're doing all that's reasonably practicable to support people if they are struggling at work. So an interesting development, one I thought I'd share with you. Now, sentencing guidelines for very large organisations, there's been some updated guidance on this. So rough and ready, I'm sure most of you are aware, but the sentencing guidelines came in 2016, and they effectively require a court to follow a staged approach when thinking about how to sentence an organisation, also individuals, but for the purposes of today, we only need to focus in on organisations. And the first step is to think about culpability, so in essence, how guilty is the organisation. And the court's got 4 criteria. It's either very high, medium, or low, and the court will hear arguments as to where the HSE thinks it sits within the guidelines and where the defence think it sits within the guidelines, and the court will make a determination. The next step is then looking at the risk of harm. And I think, again, this is one bit that's always a little bit forgotten about. The sentencing guidelines follow the law. It's about the harm risk, not the harm caused. And so I'd always encourage people to have a re-look at the sentencing guidelines and just remind themselves of that. And what the sentencing guidelines are requiring is effectively level A, risk of death, level B, risk of permanent serious injury, and level C, pretty much everything else. And then you get likelihood levels, high, medium, and low. And ultimately it becomes a little table. If it's level A, high likelihood, it's category 1. And there's 4 categories, category 1, 2, 3, and 4. Once the courts assess culpability and harm, and come up with a final culpability category and harm category, it then turns its mind to the turnover of the business, not the profits, not the cash flow or anything else, the turnover, which I always think is a little bit controversial. Just because you've got a high turnover or a large turnover, it doesn't necessarily mean that you're a profitable business. But I guess the argument is you've perhaps got more means available to you. I guess the Sentencing Guidelines Council had to come up with some way of trying to categorise businesses, but it came up with these effectively 5 categories, but only 4 that are really defined. So micro, a turnover of not being more than £2 million, a small company being £2 to £10 million, medium being £10 to £50 million, and a large organisation being one with over £50 million. But then the guidelines then had this category of a very large organisation, or a VLO, but it's never set a turnover threshold for what would be considered to be a VLO, and it's gone probably further to say there is no fixed threshold. So at every case where you've got a company with a turnover of over 50 million, there is a debate, particularly when it's in excess or well in excess of 50 million, as to whether or not the organisation could be classed as by court, as a VLO. And the previous guidelines says that it may be necessary to move outside the suggested range. So you can see here, for example, if it's high culpability harm category 1, the starting point would be 2.4, with a range of 1.5 to 6 million for a very large company. But what the sentencing guidelines are now saying is that the courts should consider fines outside the range for large companies, very large companies. So that means that it could well be in excess of £6 million, for example. And I think that's a slightly alarming development, in the sense that we're almost back to the uncertainty of sentencing. And the whole point of the sentencing guidelines was to try and bring in some consistency in sentencing, so that if you were being sentenced in, Southwark Crown Court or Southampton Crown Court or Skegness, that it didn't matter which judge you got, they all follow the same guidelines, and that you could have a vaguely relatable and predictable outcome. But I do think for VLOs, that's been somewhat thrown up in the air. And I think the one thing that's interesting is that at the moment the courts have been relatively cautious. So you can see here where you've got large organisations sort of coming up to the 184 million there with the Balcombe case. But then after that, really, you're looking at places for people 256 million to 357 million turnover now being classed as very large. When you look at the other companies where it's really more in the billions, you do begin to wonder where the line for very large and large blurs over. And I think we'll have to see how the courts develop that. But interestingly, the HSE are certainly keeping an eye on it, and we are seeing tables very similar to this one going into case summaries for prosecutions of organisations where their turnover is generally around the 100 million mark, and trying to suggest that thereafter there may well be a consideration for them to be a very large business, and putting that very much front and centre of the court's mindset when it comes to sentencing. So let's have a look at some cases that have come through in the last couple of months. Here we've got a builder from Reading given a suspended prison sentence in relation to work from height, and suspended prison sentences where someone is told they're going to have a custodial sentence, so in this case 8 months. It is suspended, so it means they don't go straight to prison, but there has to be some conditions attached to it, in this case 200 hours of unpaid work. So if the defendant in this case doesn't complete the unpaid work, then the suspended sentence could potentially be activated and then put in place and go straight to prison. Interesting, because I'm dealing with a number of work from height cases at the moment. I'm dealing with one fatality and at least a couple of others where there's been serious injuries. And the size of the organisations is very, very variable. We're dealing with some slightly smaller businesses where they've had very serious incidents. And I think there's always going to be arguments around proportionality, the resources of the business to undertake high risk work, particularly work at height. But clearly, the problem where you've got with any work from height is that even when you consider the proportionality of the safety measures that might be required, the potential high risk for working on fragile roofs, maybe in and around skylights, for example, is a real challenge in terms of trying to deal with the seriousness of the harm risk versus the proportionality of the measures that need to be taken. And here we can see, in this case, that the measures that were put in place were either inadequate to prevent or control a fall or mitigate the consequence of a fall. Indeed, that is always that balancing act, and one that I think the courts will always have to take a view on. On top of that, of course, you have a situation whereby, if no measures were put in place at all, that will then be viewed as very serious. And although I don't know the specific details of this case, given it's a fatality, given the age of the people involved, and the imposition of prison sentences, I anticipate that there was probably very little in terms of measures in this case. Dealing with this manufacturing company been fined £240,000 after a reversing HGV hit the individual in Lincolnshire. And we all know, I think, on this call, how much of a focus workplace transport has been for the HSE and indeed for other regulators. It's a huge issue. I think that I probably talk about it with clients on certainly a weekly basis, if not more often than that, segregating people versus transport, ensuring physical barriers are there where they can be, making sure traffic management plans are in place, work transport plans are in place, signage, banksman training, banksmen themselves, all of this. In fact, I've had 2 discussions already today with 2 different clients about work-related transport, just to perhaps give you a flavour of how much of a regular occurrence it is in certainly my field of people being hit by moving vehicles and or being at risk of being hit by moving vehicles. And I think the one thing that's really interesting, and it was a discussion I had with a client just recently, is very much around in-cab technology, not just in terms of HGVs and larger vehicles, but in terms of forklift trucks and other bits of kit on site, and the measures and the equipment that you can put in place on these vehicles now to try and help reduce the risk of a vehicle either hitting someone or hitting something. And it will be interesting to see in due course whether or not that translates from a case law perspective into a court saying, well, you've got this really high turnover, you've got all these means, this level of technology is available, and we've seen other, defendants use that sort of technology to reduce the risk. Why haven't you? Why was it not proportionate to do that? And I think there's always going to be a discussion about, well, how far can you go? I mean, ultimately, we all can generally cross a road without getting hit by a car, but at the same time at work, obviously everything has to be mitigated and eliminated where possible. And of course, a lot of the time at work, you're dealing with potentially more risky vehicles where there might be issues around visibility, the speed of the vehicles, the design of the vehicles, a lack of safety equipment on them, or certainly pedestrian safety equipment. And I do think we'll continue to see HGV cases and other work-related transport cases progress through the courts. And of course, in this one, the company ordered to pay £240,000 in fines. Do remember that these are criminal sentences, so the fine is money that is payable by the company within 28 days, unless there is reason for them to be given more time to pay. So it's not an insurable risk because it is a criminal sanction. A waste and recycling centre, company being fined £160,000. I thought this was quite an interesting case because it's very much around the maintenance of the vehicle in this particular instance. It's not a fatality, but clearly very serious injuries. And here you've got the HSE finding that the company had failed to undertake a risk assessment for the maintenance activity and had not devised a safe system of work. And maintenance is always one of those areas, and it's a current debate I'm having with at least 2 clients as to the difference between sort of your pre-planned maintenance, your PPMs, versus the breakdown unexpected maintenance requirements, and how you can potentially adapt any documents you've got to try and cover off an activity that was taking place following an incident. Because arguably, it's relatively easy to put a risk assessment or a safe system of work in place, or both, in relation to a PPM, so some planned maintenance. But if you're dealing with a breakdown or something unexpected, it's really challenging to try and then start evidencing how the maintenance engineer has undertaken a risk assessment or come up with a safe system of work. Because in essence, until they've picked it all apart and found out what's gone wrong, they don't necessarily know how to fix it straight away, whether you need specialist parts or whatever. But then also, you can't really continue to sort of document every single aspect of the breakdown repair that you're doing from a risk assessment point of view, because often you have to deal with the issue first that you would be risk assessing in advance. It's kind of a bit back to front, and I do think we do have these issues with these maintenance type cases, particularly where there's been access to dangerous moving parts. There's always, maintenance people suggesting that they might need to run a bit of kit to see why it's not running properly, with guarding removed, etc., which is always, a bit of a challenge in terms of trying to change that mindset in some ways, or certainly, make that operation safe. But at the same time, ultimately, it is for an organisation to ensure that regular activity and regular tasks where risk is posed is being risk assessed and a safe system of work devised. Certainly, that can be understood by the engineer or whoever is being asked to undertake that work as well. And clearly, in this case, the company fell short of that. Back to my point earlier in relation to work-related transport and issues around people being hit by moving vehicles or becoming entangled with them. In this case, again, we're coming back, aren't we, to HSE investigation finding that the equipment that was provided was not safe or suitable for the task. Again, a failure to risk assess the system of work for emptying bins in this case. Traffic management not being ideal, and that people and vehicles were working in close proximity. And I have some sympathy with organisations where they have a lot of movements on a daily basis, where particularly in yard spaces where there might be tight or confined space, where you might have a lot of vehicles moving around in close proximity to each other and potentially pedestrians, and also where items might be being moved around. And so coming up with a traffic management plan for items that could just be put in one place one day and somewhere else the next is always going to be a bit of a challenge. But clearly in this case, it was felt by the HSE that this operation had not been properly thought through. And as we can see, a young lad sustaining serious injuries to their ankle following getting caught in the straps and being pulled to the ground and then being run over, and perhaps lucky to have kept his ankle from the information that's been provided. But again, this case, perhaps just pulling together a few themes that I've been trying to pull together, and that is that we're still seeing, in essence, court cases from the HSE being brought around the wrong equipment being used, failure to ensure that work is properly risk assessed, failure to ensure that work is being properly set out in safe systems of work or equivalent work instructions, etc. and that one of the main issues in terms of one of the risks is again around people versus transport, and I think that will be an area where there will always be some challenges, but certainly one that will always remain, I suspect, high up on the HSE's list of things to keep an eye on. So just some concluding remarks, because I'm conscious that I've, as usual, overran slightly, and Joanne may have got some questions for me in the background, I'm not entirely sure. I'll just pull it all together very quickly now. Health, I think, is increasingly more relevant in the health and safety world, and I mean relevant in the sense of my health and safety world, where we're dealing with inquiries from regulators, and I anticipate at some point there will be a prosecution, maybe including mental health within an incident or something else to begin with, but I think it will start to creep in a lot more in the legal world. Again, and we're seeing that with active inquiries by regulators in terms of what measures in place some organisations have. HSE still undergoing some internal changes. Some of those, are having a good impact, I think, like the triage system, provided that that gets tightened up. HSE Legal Services Division, I must confess I wasn't a fan when it first came in, but it does seem to be, now they're getting sort of their feet under the table, it feels like we're getting a bit more consistency in decision making, which is always helpful. Sentencing guidelines still biting at all levels, and of course Magistrates Court ticketed district judges are now able to impose these unlimited fines, so we are seeing a lot more of these large cases taking place and large fines taking place within the Magistrates Courts, which is helpful in the sense that your first right of appeal, if you want to do so, is up to the Crown Court, but it does add sometimes a little bit of nervousness staying in the Magistrates Court for a potentially 7-figure fine. But from my perspective, the one thing that I think is really important, I touched on this earlier, is the importance of getting the investigations right, where you have had a major incident or a serious incident, and being very aware of how to respond to the HSE, not just simply, for example, sending everything to the triage team and hoping for the best. I would say that every opportunity you have to engage with the HSE is an opportunity to start trying to put forward the good points of your organisation, the good stuff that you do, and trying to almost use it as a subtle implied tool to get across to them that actually they may not need to look at this, because yes, you may have had something go wrong, but you're on top of it and you're in charge of your organisation and you know how to deal with it. And I think any opportunity where you don't get to try and engage positively with the HSE, particularly off the back of an accident, is an opportunity missed. I know some of my colleagues across the industry maybe take a slightly more confrontational approach, but I think in the era of FFI, enforcement action, and everything else, if we want to keep a business going, sometimes you actually have to take a more pragmatic approach to how you deal with the regulator, but make sure that they are getting the information they need in a way that they will understand it. And I think that communication piece with HSE has never been more important in particular. So hopefully that's been of some use to you all. I do hope so. I'll try and stop sharing my screen so I can see Jo. Jo, hello.
Hello, that's great. Thank you very much, Matt. As always, I know certainly for myself, and I'm probably not alone with this, every time I attend a legal update, my mind suddenly starts going, got to check this, got to check that. Am I okay with this? Especially when you're covering sort of cases that maybe are close to home with regards to sort of the situations, the tasks that people actually do. Interesting to see that on the HSE's AGM that focus on health and specifically mental health and well-being being more greatly increased and emphasised, which I suppose if I look at the stuff I do on a day-to-day basis, more and more of my clients are certainly focusing on that area. It's as though they go, right, we're quite happy with what we're doing everywhere else. We've been doing these risk assessments, we've been putting stuff in place for years. This is quite a new topic or a newer topic for them to deal with. And that fee for intervention, £183 per hour, Yeah, it's and when you said about that inconsistency of inspectors, it's if you suddenly you could be one company getting quite a huge bill and another company getting a smaller bill. It doesn't seem very fair, does it? So hopefully, if they are trying to balance out, that should be
Yeah,
beneficial, I would
I mean,
hope.
it's an interesting point, Jay, because I do think that I think sometimes a lot of it also comes down to how good a relationship you build with your HSE inspector, particularly
Hmm.
following an incident. And again, it comes to that sort of last point I made about, I think sometimes, particularly with with lawyers, the HSE are naturally defensive, and I think we're all got a degree of healthy suspicion against each other. But it's putting that little detail to one side. I do think sometimes with HSE or with any organisation or any individual, sometimes people read an email the way they want to read it, with the
Yeah.
tone of voice in their head, and it doesn't matter how diplomatic you try to be and how you write it, it's just always going
Hmm.
to be taken the wrong way. And I think when you're in litigation or there's a risk of litigation or seriously following a serious incident, sometimes my approach is to try and maybe pick up the phone to the HSE inspector and try and talk things through and then follow up in
Hmm.
writing. And that way, at least you're clear that how you're being received is the way you want to be received, even if you're saying something that they're not going to like.
I think it's that thought that the regulator, at the end of the day, they are human beings and they've got a job to do.
Yeah,
And I suppose that comes on to a question with regards to sort of RIDDOR. You did touch on it in the presentation. Is when you are completing that RIDDOR form, however severe the incident is, whether it's just I think the ones that always get me when it's just been someone off for over 7 days and they're actually fine, everything's okay. But is it good practice to include as much as possible? So you've done your investigation, you're still within the right timescale of sending the RIDDOR report in. That if you said, oh, we've reviewed this, we've reviewed that, we've updated this, etc., put a lot of detail in that report, or leave everything and wait for them to just ask you the questions.
I think it's very case specific.
Of course.
I don't think there's a one size fits
Yeah.
all answer. I think the one thing that I'm seeing a lot of at the moment, if it helps, is um, clients not having in confirmation the nature of the injury and
Mhm.
why someone is either saying it's a specified injury or why they're saying they need to be off work for such a period of time
Mhm.
and how that's been caused. And so one of the things that is delaying some riddles going in is that confirmation of actually ascertaining whether or not it is a specified injury or whether it's an LTI.
Yeah.
Because then obviously you can't complete the form, and sometimes you're only as good as the information you're provided.
Mhm.
And it may well be that we've got cases where you know we had a riddle go in relatively recently because the individual was fine, took themselves to hospital, had um, uh, you know a bit of an issue with their shoulder. Um, but then it turns out when they did some scans a week or two later on that it had a fracture,
Mhm.
and then it stops. It changes then, and then
Changes. Yeah.
suddenly you're having to update a regulator if you've already done the RIDDOR that
Yes.
it's now gone from being an LTI to a specified injury. And I think it's that sort of debate about how quickly to report um, that is sometimes causing a bit of a challenge.
And it's very often, sometimes depending on the size of organisation, the communication between the people that know if that person's back and the person that's got to do the report. So very often they can be different departments in different areas of the country and don't always necessarily talk as well together. So that can always, be an impact on that delay, unfortunately. And
Yeah.
but it is your responsibility. Just seeing one come in this particular sphere of influence, are we more regulated and enlightened than other countries? Thinking of a European view is different.
Oh, I don't know. I'm not sure if I can answer that really on the basis that I don't practice outside of England and Wales. But
Hmm.
I do think there are some very interesting points about British health and safety law that probably would suggest we are slightly more on it than other countries. First of all, the 1974 Act is well before any sort of European legislation regulations come in. So we've always had the 1974 Act, and it's always been criminal offence and enforceable through the criminal courts. I anticipate that there are going to probably be more compliance areas across Europe where there is probably stricter regimes in terms of day-to-day compliance and requirements and what they envisage being a legal requirement or a best standard, etc. I think sometimes we have a little bit of catching up on that. But I do think that we have quite a strong enforcement of health and safety law in the UK, and in particular in relation to the health and safety executive, that certainly don't shy away from getting involved and stuck in.
Excellent. So question with regards to, we've talked about this emphasis certainly on the mental health and well-being. When it comes to that area though, and an organisation looking at the factors that can have an impact on somebody's well-being, can that really be a bit of a challenge though? Is the factors business influence or external to the business?
I mean, it's such a big topic. There is a huge amount of guidance out there, not least on the HSE's own website, in relation to things to consider, things like the risk management standards and things like that the HSE put in place, or suggested. I mean, ultimately, an organisation is going to have to work, I would say, quite closely with its HR function to ensure that whatever measures HR might already have in place and what support is there, the health and safety team can work into that and tap into that, and that there's a consistent message across the organisation. Sometimes I've found that sometimes with the slightly larger organisations, you've got the health and safety team doing sort of their thing, and then the HR people doing their thing, and it doesn't always kind of connect very well.
Yeah.
And sometimes just double up on the work and double up on the resource for no reason. So I think, like all things in the workplace, the better communication there is about a theme or a topic is more important than who owns it.
Unfortunately, as we probably anticipated, we've vastly run out of time. We're in our last minute of the session, so I'd like to take this opportunity, Matt, to thank you so much for providing a great update. And I think that there are still probably going to be some questions coming in, but what I'll do is we'll be able to get round to those and send any replies back. So yeah, I'd like to just thank you. I'd like to remind everybody that if you're a member of WRSM, the presentations are recorded and they are available on the website to view at a later date, and that there are a number of events coming up. So just to remind you to go and have a look at the events page, and certainly the Scottish branch, you've got a session that's coming up on the 27th. It links quite nicely into this with personal liability directors and senior managers for health and safety offences, what you need to know and how to protect yourself. And certainly from our branch's point of view, our next session is on the 17th of November with a lovely title of AI or Die. So, and that, having listened to the scoping session, I'm really excited about that one, because it's certainly looking at the impact, that the risk of using AI within our industries. So again, thank you to everybody for joining us today. Look forward to seeing you at next future events, and thank you again, Matt.
My pleasure, thank you.
Cheers.